I've been watching so many high-profile cases. We've got the Laundries with the Gabby Petito family in the civil case. We've got a criminal case with Brian Kohlberger, accused of murdering 4 university students. We've got Alec Baldwin in the shooting on the movie set. And we got Alex Murdaugh, accused of shooting his wife and son. And there are so many more, sadly. So understanding reasonable doubt will help you to understand how each side will form their evidence, whether it be direct or circumstantial. They will convince a jury how to come back with a verdict that favors their position. So let's get started. There are 2 types of standard of proof. In civil court, it is based on the balance of probabilities, i.e. 51%. It is more likely than not. For criminal cases, the standard is beyond reasonable doubt. And in 2020, UK judges were told to replace the phrase beyond reasonable doubt in criminal cases, which we will discuss what that replacement is in just a bit. As I'm telling you now, if you don't know what beyond a reasonable doubt is, I'm not convinced the new guidance is any better, but you can decide for yourself. So in this clip that we're going to watch, we're going to see how an advocate representing a party will, in opening statements, give their interpretation of how a jury should come to beyond a reasonable doubt. I will discuss how the UK judges will deal with this when there's a trial. Each of us understand the concept of burden of proof differently, as we'll hear shortly from a couple of judges, one from the US and one from the UK. So let's listen to this attorney's interpretation just now.
And a lot of times people hear, oh, it's just a circumstantial case, but the law says otherwise. The law says that circumstantial evidence is just as good as direct evidence. And what's the difference between the two? Direct evidence is supposedly about to storm out here, from what I'm told. Direct evidence is if it's sunny outside, and a witness goes outside and it's sunny, and they come in here and they get on that witness stand, and because they saw it raining, they sit on the stand and said, I was just outside and I saw it raining. I saw it raining. That's direct evidence. They actually saw it raining. But to give you an example of what circumstantial evidence is if the witness goes into a room where all the curtains are drawn, and when they go into that room, it's sunny outside and everything's dry. And while they're in that room, they see it darken behind the shades. They hear thunder. They hear the wind blowing. They hear the sound of raindrops on the roof. And then they open up the door, and it's not raining, but everything is wet. There's puddles in the driveway. There's puddles in the street. There's puddles in the yard. There's limbs down all over the ground. And then they come in here and say, yeah, it was raining. Didn't actually see it raining, but those circumstances are beyond any reasonable doubt that it was actually raining. Now, I guess it's possible that somebody could have been standing outside their window and beating a drum to sound like thunder and blowing a fan to make it seem like it was the wind and somehow got enough water to coat the entire neighborhood. But that's not a reasonable doubt. Everybody understand that distinction? That's not a reasonable doubt.
I kid you not, when I first saw this, I thought to myself, what if you're a sound sleeper and you're taking a nap and you don't hear the thunder? You might see broken branches because there could have been a tree cutter out there, but you wake up and your grass is all wet, your flowers in your garden are dripping. Can you still assume it rained? What if your neighbor hosed down your garden? Is that another reasonable explanation? Then I found this clip. Let's watch.
So I'm looking out for their house while they're gone.
Okay.
Watering their flowers.
Okay. Well, that's cool. Now, do you have like ID and all?
Oh, no, man. I'm not going to give you no ID.
Why not?
I ain't did nothing wrong.
Well, you look, listen. I'm not saying do nothing wrong.
Doc, listen,
there's a suspicious person.
Look, I used to be a police officer in Goodwater. Don't come here with that. Okay?
Look, man, don't do this to me. There's a suspicious person in the yard, and if you're not one to identify yourself.
I don't have to identify myself. It's not a stop and identify state. That guy know me. He came to my store that got broke in. I live right over there across the street. Who called y'all?
That's what we got to figure out. But first,
he
don't live here. I'm not saying nothing about.
You have no right to approach me if I ain't did nothing suspicious or nothing wrong. Told him I'm a pastor. I pastor until I don't want to hear. Sir. You want to lock me up? Lock me up.
Nobody wants to lock
me up. I'm not showing y'all anything. I'm going to continue to water these flowers. I don't care who called y'all. Lock me up and see what happens. I want you to.
Hey, man, just come here and talk to us. What?
Now, do you think it's unreasonable that there could be another reason besides rain that made the garden and grass all wet, and the pavement and water everywhere? Let's listen to a judge from America explain this concept. Before ending this video, I will let you know what the police officers decided to do with this apparently good neighbor doing a good deed. The result may surprise you, so stick around till the end.
Hi, I'm Judge Alex, and a lot of times I get questions about what exactly is reasonable doubt. If a case has to be proven beyond every reasonable doubt, how does a jury know what that means? And to be honest with you, even the lawyers have difficulty with that concept. There was an explanation that I give to jurors all the time in criminal cases, and it seems to make it a lot more understandable. Because if you go by the jury instructions, the standard jury instructions in Florida, they actually are more confusing than helpful. And that's probably true for just about every state. So what I would tell jurors is this. How many of you drove here today? Or think about yourself and your car where you parked your car today. Let's assume that when you parked your car today, you got out and you noticed that the mileage on it was 5,000 miles, and you thought to yourself, you know, I have to change my oil soon. And you went inside to your office. You're in the office all day. You walk out of your office, go to your car, you get it in the car. It's in the same exact space where you left it. The miles on the odometer still say 5,000. Would you have a reasonable doubt about whether your car was there all day? Probably not. Now, the reality is your car might not have been all day parked in that space. Your car might have been on the flatbed pickup truck going up and down the highway, because somebody could have backed up a flatbed pickup truck, pulled your car onto it, driven up and down the expressway all day while you were at work, and then before you came out, come back and drop the car in the same spot. Now, that's possible. That's not impossible, right? But is it reasonable to believe that that is what happened? Most people would say no. Now, let's say that you left work, and when you went out to your car, there was a police officer standing there, and he said, "Are you the owner of this car?" We were trying to find the owner because early this morning when it was parked here, a flatbed pickup truck came and picked it up. And just a few moments ago, that same flatbed came back and dropped the car in the same position. Now, assuming that you believe the officer, because let's face it, the officer might be pulling your leg or might be lying to you. But if you believe the officer, would you then have a reasonable doubt about whether your car was there all day? Most people would say yes. So you see, a reasonable doubt comes from the evidence, the facts that you have, the lack of evidence, things like that. Now, some people might have a reasonable doubt without the police officer. Some people might say, you know what, I can imagine I parked my car there. I might have a doubt when I come out and find the car still there as to whether it was there or not. Well, that's their decision. And other people might not have a reasonable doubt. That is what the jury does. They discuss the doubts they have and whether those doubts are reasonable when they go back in the jury room, and together as a jury, they come to a conclusion about whether the case has been proven beyond every reasonable doubt. I hope that clarifies the concept of reasonable doubt.
So Judge Alex makes a very good point. There seems to be a lot of Alexes lately. You never hear that name, and then all of a sudden you hear them all the time. So anyway, he makes a very good point that you might not have caught. A police officer is a law enforcement agent. So you might lean to believing their word above someone else's. But what if your belief system is tainted and you've been duped by the police, because they are allowed to use trickery? And in this hearing, Alex Murdaugh trial, day 15, the police officer that was actually in charge of the investigation admits to using trickery when questioning the defendant. By the time the defendant's solicitors were cross-examining him, they actually caught him out in another lie on misleading the grand jury. So that alone would cause me to believe that there's reasonable doubt in this case. In the UK, the courts recognize that each jurist will apply the concept differently. So the new way to explain it to a jury has been replaced. Now, I couldn't find a clip of a UK judge explaining it, but I have found the Crown Court Compendium, which is the judge's guidance book. So judges in the UK are now guided to replace beyond reasonable doubt with satisfied that the jury is sure. Now, this change was over concerns of confusing the jury, according to the Telegraph in 2020. And the Crown Court Compendium for judges, this is the guidance that I mentioned that judges use, went through a complete overhaul in June of 2022 and consolidated all its previous guidance for judges. So let's take a look at what it now reads. So the guidance for judges confirms that any question dealing with the standard of proof is one that most judges dread. To have to define what is meant by reasonable doubt and what is meant by being sure requires an answer difficult to articulate and likely to confuse. No doubt this is why the Judicial Studies Board sought to avoid it in the direction. Oh, this is when you give directions to the jury. So this came about because the jury in a case asked exactly that question, specifically whether the standard of proof was 100% certainty or beyond a reasonable doubt. And if it was the latter, what does beyond a reasonable doubt actually mean? This question to the jurors was answered this way in agreement by the trial judge and the advocates that were working on the case. And they basically said to the jury that the jury was not required to be 100% certain. Ooh, that has a bit of a different meaning than the actual question that they asked, but we can debate on that. And they also said that to be sure and to have a beyond reasonable doubt meant the exact same thing. And a reasonable doubt was the sort of doubt that might affect the jurors' minds if they were making decisions of matters of importance with their own affairs in their own lives. So this was then appealed. This is a long story short, but the Court of Appeals said that the answer that the trial judge gave was correct and appropriate, given the specific questions that had been raised by the jury. But the concern was about being certain. However, the court suggested that the judge had been unwise to refer to certain when dealing with a jury question that did not, in fact, contain those words. Best to avoid the word certain and to avoid even using beyond a reasonable doubt. If faced with that question from a jury seeking further guidance on this topic, it is reminded that the prosecution has to make the jury sure in order to prove guilt is probable. That is the safest course to adopt. Well, I don't know about you, but I think what the court is trying to say is that being certain is not the threshold, but having certainty of being sure that because the prosecution has the burden of proof to you that the defendant is guilty, if you are not sure that they have, then you must find the defendant not guilty, because it's not for the defendant to prove he or she is innocent. To help us understand this, I have asked a science consultant that's done a lot of consulting for new scientists, and he's an author, and I think he would be great in explaining certainty and reasoning and difficult concepts. He's got a new book out, and we're going to go through that and review it. His name is author Marcus Chown, and I'm hoping to be talking to him in an upcoming video, and it will fit into our playlist, introducing you to new authors. So I've left a link to his website, and I hope you check it out and order his latest book so that you'll have a bit of understanding when we discuss it. Now, I promised you that I would tell you what happened to this poor chap that was doing a good deed for his neighbor. Well, you know the old saying, no good deed goes unpunished. This poor chap received a charge of obstruction of justice for not giving his name to the police officers. I wonder if the police officers should listen to our talk with Marcus Chown on, you know, rationalizing and being able to reason out a decision. So anyway, it was very sad, but yeah, I did. It's I've left a link to theirs in the description area as well, to that video, the police body cam. But it's really quite interesting because they don't actually tell you what happens. They just show the police carting him off to the police station. But in the chat, someone wrote that he was, that it was, you know, thrown out of court. But still sad. Well, I hope you found today's video interesting, and information is power. Why not subscribe and watch more of our videos? If you need legal help, contact Legal Minded Friends.